of speech and expression का medium, but there is being censored by central authority. फिल्म में भी central authority द्वारा censor होता है by central authority and subject to scrutiny of courts. If the content is obscene or has a potential to disturb public order, that also subject to scrutiny of courts का scrutiny. Supreme Court in a judgment has said that film is contrary to other forms of expressions, generates more indulge emotions. Films also take part in the emotions, indulge contrary to other forms of expressions. These emotions have tendency of harming the social or public order. फिल्म में भी पब्लिक ऑर्डर को टेंडेंसी को हार्म करता है. सो टू प्रिवेंटिंग एनी काइंड ऑफ डिसऑर्डर, सर्टिफिकेशन प्रोसेस इन द फिल्म इज डिफरेंट. सो देश में फिल्म से भी लोगों को प्रभावित करता है. द पावर्स, प्रिविलेज एंड इम्यूनिटीज ऑफ पार्लियामेंट एंड इट्स मेंबर्स. एनबीसीएच आर्टिकल 105 immunity. Constitution leave from for a large number of uncodified and unenumerated privileges to continue. Assess the reason for the absence of legal codification of the parliamentary privileges. पार्लियामेंट नेताओं को क्या छूट मिलता है? आर्टिकल 105 कॉन्स्टिट्यूशन प्रोवाइड पावर्स, प्रिविलेजेस एंड इम्यूनिटी टू द पार्लियामेंट को एंड इट्स मेंबर्स सब्जेक्ट टू प्रोविजन ऑफ द कॉन्स्टिट्यूशंस. सरकार भी उनको जेल में नहीं डाल सकता एमपी को. The rules and standing orders regulating the procedure of the parliament, subject to the provision of the constitutions. Parliament Article 105 states, 105(3) states that power, privilege and the immunities of the members and committees of the parliament will be determined by the law which should be passed in parliament. Some of the powers, privilege and the immunities are freedom of speech in parliament. No member shall be liable to any proceedings. नहीं होगा. Any court and court law in respect of any time said anything said or any vote given by him in parliament में और any committee में कुछ भी बोलने से proceedings in court में नहीं होगा. The reason of the absence of legal codification of the parliamentary privileges are many, and one of them the nature of work that will take place in parliament, which is dynamic in nature. Codifying the privileges, it puts limit on the parliamentary freedom which may not be held in its proceedings. Parliament में privileges है. What that place parliament which is dynamic in nature puts a limit parliamentary the factors. Actually, federal principle is dominant in our constitutions, and that principle is one of its basic features. But it is equally true that federalism under the Indian constitution leans in favor of strong center, and a feature that militates against the concept of strong federalism. Federal principle is dominant in our constitution, and the principle Indian combines the feature of a federal government. The president delayed in communicating death sentence. President delayed in communicating death sentence has entered public debates. Public debates में है as a denial of justice denial. Should be there will limit. Several reject such petitions. Article 72 of the Constitutions. Article 72 of the Constitutions. President और कमेटी द डेथ सेंटेंस को छोड़ सकते हैं और for convict with no time period within which decide over the mercy petitions. They make the delay of deciding such petitions within the constitutional provision के अंदर. Not to ultra wires. Both the delay over accepting and rejecting such mercy petitions delay कर सकते हैं. Also suffering of the petitions with physical stress and trauma, which is cruel and it becomes a question of human rights. Physical stress. The decision of accept stress and trauma. Decision of accept stress and trauma, which is a cruel and becomes question of human rights. Independent administrative procedure and not a commentary over judiciary. It is the administrative nature of the mercy petitions. administrative nature of mercy, which results delay as it often get torn between need of justice and political considerations. Politically need and justice. Decision to accept reject such emancipation is with a home ministry and thus become an independent administrative procedures, not a commentary over judiciary. Commentary over judiciary. Reject with regard to specifying the time limit of the president to accept or reject the mercy petitions, Kemapat petitions, the apex court verdict in Rajiv Gandhi assassination case, in which it commuted death sentence to convict to life kele. In a view of the inordinate and unreasonable delay in considering the mercy petition is very important. It clearly calls for a time limit in accepting or rejecting such mercy petitions, because in the absence of concrete guidelines, the unreasonable and inordinate would remain subjective. The keeping mind of the rights of the convict and sufferings arising out of the long delays, there should be time limits specified for the president to accept or reject mercy petitions. Actually, political consideration, home ministry's life sentence of the convict to life in view of ordinate and unreasonable delay. मृत्युदंड से लाइफ जीवन, it clearly calls for a time limit रहना चाहिए. It becomes the independent administrative, the commentary not over the judiciary. Commentary, it is administrative nature of these mercy petitions, which result delay. Thus the right of the clean environment. Initial enter legal regulation on burning crackers during Diwali time. Discuss the right of Article 21 of Indian Constitution. Article 21 of the Indian Constitution protects the life and personal liberty of the citizens. Life and Supreme Court in various Supreme Court कुछ भी लोग देश को बदल देंगे. Nothing. It never possible. Giving a wide interpretation to the articles and observe that the right to life is not a merely confined to animal existence of the survival. Supreme Court in various decisions is given a very wide interpretation in the articles, includes within the ambit and the right, human dignity and human right to life. We live with human dignity के साथ, all those aspects of life which go to make life meaning, complete and worth living. Complete and worth living